Hello and welcome back. My name is LAKSHAYA and I'm an intern at LEXIS and Co. The topic for the day is Dowry, Death and Indian Judiciary Part 2. Let's continue. The appropriate aim of criminal law is not simply dowry concern, but also the violence associated with dowry. Due to the failure of dowry regulations and an increase in the number of dowry deaths, the Criminal Code was amended in 1983 and 1986, adding Section 304B, 498A in summary. There are four scenarios in which married women is subjected to cruelty and harassment that results in the commission of an offence. The offence of dowry death is defined as a woman's death caused by burns or bodily injury or other unnatural circumstances within 7 years of a marriage, where it is proven that she was harassed or subject to cruelty by her husband or his relatives in relation to dowry and is punishable by a sentence of 7 years to life imprisonment. 7 years would be regarded a cut period due to the 7 steps made by the bride and groom of the sacred nuptial fire to complete their marriage, each step being equal to 1 year. The term dowry is not defined in the Indian Penal Code, but Section 304B explanation states that it has the same meaning as the Dowry Prohibition Act 1961, which is defined in Section 2, subsection 1. Dowry death essential under Section 304B are burns or bodily harm caused death or death occurred under unusual circumstances. Within 7 years of marriage, she would have died, is the second criterion. The third criterion is husband or relatives must have treated this woman cruelly or harassed her. Cruelty or harassment should occur in the context of dowry demand and shortly before death. Section 174 and 176 respectively deal with the police and judicial investigations and inquiries into the reasons of unnatural deaths. If a woman dies within 7 years of marriage in a suicide or other suspicious circumstances, the Amendment Statute in 1983 makes it essential for police to transfer the body for post-mortem examination. It also gives executive magistrate the authority to investigate a woman's death under comparable circumstances. If it is established that a woman was exposed to cruelty or harassment for or in connection with any demand for dowry death under Section 304B, she will be charged under Section 113B of the Indian Evidence Act. The burden of proof in dowry death has been changed to Section 113B, which requires the court to presume that a dowry death was caused by the person who was proved to have subjected the woman to cruelty or harassment shortly before her death. Dowry death is a social blight that is a hot topic in Indian society. Deterrent punishment for dowry deaths, perpetrators by women welfare organizations, police, public servants, and judiciary. It can be seen as the Indian government, in collaboration with Indian judiciary, creates cooperative and supporting legislation to protect women's lives and dignity, as well as to provide additional justice to the victims of harassment or cruelty by their husbands and relatives. Changes in the educational system have improved women's education status and door-to-door job services, which will reduce dowry deaths. Nonetheless, specific corrective measures must be implemented in order to eliminate or at least reduce the social threat of dowry death. But most crucially, a public will and determination to reject the materialistic greed of dowry is required. In order to reduce the number of dowry killings, harassment, and cruelty, more female police officers should be recruited and trained to be accessible in the event of an unnatural death of a woman. The investigation cannot be conducted below the rank of Assistant Commissioner in the interest of the competent investigation and justice. Suicide abatement should be punished with up to 7 years in prison, and logical, realistic solutions to the aforementioned issues would be undoubtedly be beneficial. That was all. Thank you.